Hello and greetings of the day. Are you one of the DV 2022 winners? If you answered yes, congratulations. You were lucky enough to be chosen at random by a computer program. In today's video, Krishna and Supriya discuss whether or not to engage in the DV 2022 litigation, as well as the recent DV 2022 related trend.
Good day, Krishna. I recall that in the last video, we discussed the DV 2021 lawsuit. You mentioned that the DV 2022 lawsuit could be difficult. What exactly do you imply when you say that?
I agree. I mentioned in the prior video that the DV 2022 lawsuit could be difficult. The reason I mentioned, I will try my best to explain it concisely.
Krishna, is it better to take part in the lawsuit or not? Also, let us know your recommendations.
Participating or not participating in the lawsuit isn't a simple answer to this question. In short, it will be highly dependent on your circumstances, which I aim to discuss to help you better grasp the issue and the factors to consider. I will try to explain everything as simply as possible. Be aware of the fact that becoming a plaintiff in a case does not guarantee a visa interview or a diversity visa. In most cases, whether you obtain a visa or not, upfront partial payment is necessary, and even if they receive a visa for reasons unrelated to the litigation, they must pay the total cost of participating in the lawsuit.
I now understand that, even if winners acquire a visa for reasons unrelated to the litigation, they must pay the price for participating in the lawsuit. Lawyers, on the other hand, require the fund to fight for the case, right?
Yes, you are right, Supriya. Furthermore, two basic techniques have been attempted by lawyers in previous years' DV lawsuits, which I will discuss ahead. The lawyers persuade a judge that a policy prohibiting DV interview schedule is, in fact, illegal and that the regulation should be halted, an injunction is issued, and the victims, also known as plaintiffs, are granted a visa interview. In the past, lawyers have succeeded in obtaining injunctions against the following two policies, though not all cases were successful. One is the presidential proclamation, entry bans, visa bans, and the other is tier prioritization. Both of these initiatives are no longer relevant because they have been officially ended, and they cannot be utilized as a foundation for DV 2022 relief. There is a claim that the tier policy is still in effect despite its removal from the records, but this would have to be proven in a court of law, and there appears to be a lack of evidence at the moment.
I learn now what the major foundation was for the prior year's diversity visa lawsuits. Hey, all the viewer, if you like the content of this video, give it a thumbs up.
In recent days there have been some improvements in the Department of State's policy on consular operations since Reena Bitter was appointed as Assistant Secretary of State for Consular Affairs. The most noticeable changes are: 1. The tier prioritizing instruction has been removed. Second, for diversity visas, the documentary qualification stage has been eliminated, allowing KCC to focus on scheduling. We'll have a separate video on this in the coming days. Third, for Iraq and Afghanistan, where US embassies are no longer open, instructions for consular reassignment were published. Morrison Urena's scheduled lawsuit, Hamad vs Blinken, with 25 plaintiffs, was voluntarily dismissed by the firm itself after the update was released by the State Department regarding consular reassignment. The most recent one is Presidential Proclamation 10141, which revoked Presidential Proclamations pp. 9645 and 9983, which had suspended entry into the United States of certain nationals from Burma, Eritrea, Iran, Kyrgyzstan, Libya, Nigeria, North Korea, Somalia, Sudan, Syria, Tanzania, Venezuela, and Yemen, based on visa type. We will have a separate video on this. This does not, however, imply that the outlook for DV 2022 is all favorable. The world is currently seeing another wave of COVID-19, which has impacted operations in several countries. There are also political, diplomatic, and internal issues in areas like Russia, Belarus, Myanmar, and Ethiopia. Furthermore, we believe that embassies such as Abu Dhabi are still devoting resources to the processing of Afghan refugees, and as a result, they may not be fully operational. In India, in-person appointments have also been discontinued. Local embassy policies may potentially have an impact on processing, but it's unclear how much this will affect DV 2022.
Okay, we should agree on the fact that these changes somehow show a sign of relief for the DV 2022 winners. As you might be aware, before 2019, diversity visas were assigned appointment dates after the DS-260 was submitted, documents reviewed, and the interview would typically be arranged a month after the case became current in the visa bulletin. So, what's next for the DV 2022 winners? Will the winners be able to move their cases to another embassy if their home embassy does not have any opening slots for the diversity visa?
An unreasonable delay is where lawyers try to persuade a judge for the case of DV 2022. Until now, we've seen judges accept delays caused by factors beyond the embassy's or DOS control, such as COVID-19 related disruptions, staff shortages, local government policy, the country's security situation, and diplomatic concerns as acceptable. In past lawsuits, however, courts have found delays induced by unconstitutional regulations to be excessive. In terms of switching off embassies, this proved to be the most successful approach for dealing with embassy troubles in 2021, but it didn't always pay off, as some unintentionally shifted from embassies that started working later to those that slowed down towards the end. To transfer the case, applicants do not need to unlock their DS-260. The KCC frequently ignores your choice of the embassy and assigns applicants to one based on their country of residency. If applicants have not yet been scheduled to transfer to another embassy, KCC recommends that applicants contact the embassy. If the interview is already scheduled, KCC recommends that applicants first contact the embassy to which they wish to transfer, obtain their permission, and then contact the embassy that currently holds the applicant's case to transfer it to, or applicants can just ask the new embassy to request your case. The policies in place at the target embassy play a big role in whether or not a case transfer is accepted. Many embassies refuse to accept candidates from countries beyond their own.
Thank you so much, Krishna, for clarifying what is happening with the DV 2022 in the present circumstances and whether or not to join in the DV 2022 case at this early level. I suggest that winners should wait a few more months to see what happens next. Also, be updated with the local embassies. In the fiscal year 2021, many embassies began working on DV cases at the last hour. In addition, for those who have submitted their DS-260, with the low case and the case number is current in the visa bulletin, they should reconsider joining the lawsuit at this point.
Remember that the information shared by Mr. Krishna and Ms. Supriya is not intended to be legal advice, and you will eventually have to make decisions for yourself and be responsible for the consequences. Furthermore, if there is any news regarding the Diversity Visa 2022, we will keep you all updated via YouTube videos and shorts.
Please let us know what you think about how the government is treating the DV 2022 cases in the comments section below. Follow at theDVObserver on Twitter and subscribe to our YouTube channel to stay up to date on the diversity visa process. Thank you for watching this video till the end. Good day. And yes, don't forget to check our other videos related to the diversity visa.